You have 5 minutes. Please go ahead.
Thank you. I'm glad I could be here. Just a few days ago, my wife gave birth to our daughter. And during her pretty long labor, doctors presented her with different options. So of course, new to me, but meso or oxytocin to move things along. They needed to move things along faster. Epidural, forceps, or vacuum, or C-section was discussed at one point. So in our vulnerable state, we trusted that the options the doctors presented were good options. We also wanted to know what the doctor thought was the best option, and frankly, we went with it every time. Now, medical assistance in dying, or assisted suicide, or consensual homicide, or whatever you want to call it, is not healthcare. At least it's fundamentally distinct from any other medical service. Advising someone to have a C-section or chemotherapy or pain medication is not a crime, but encouraging or inducing someone to end their own life is a crime. If MAID were simply another healthcare service, we wouldn't be here today discussing substantive amendments to the criminal code. Medical services are not regulated by the criminal code. We are wrestling here with when we as a society will permit some people to kill others. That's why this is before Parliament. The fundamental problem with this bill, as we see it, is that it fails to take this seriously enough. It's almost flippant in its treatment of the deliberate termination.
Excuse me, Mr. Chairman. The interpreters are unable to interpret because Mr. Sikkema is speaking too quickly, and they do not have the text. It seems that you don't have this information. Apologies to Mr. Sikkema, but I believe that we should be able to hear correctly.
Mr. Sikkema, if you can please slow down a little bit in your remarks. I've stopped the time so that you don't get penalized for this. But if you could also move your microphone just a little bit above, like between your nose and your mouth, so that we don't hear that popping sound as well. You want to give it a go? Thank you.
Sure.
Go ahead.
Apologies to the translators. I meant to flip this to them a little while ago. Our current law, as amended by Bill C-14, is already interpreted to allow doctors to euthanize patients who have a decade or more of life ahead. Our current law already fails to prevent doctors from suggesting MAID without being asked, at least listing it as an option, which can send a powerful message to the sick and disabled that someone thinks their life isn't worth living. Bill C-7 not only fails to address those problems, as identified by the United Nations Special Rapporteur, among others, but it makes them worse. If Bill C-7 passes, it will be possible for a person with a serious illness to go to their doctor's office, have their doctor suggest MAID as an option for them, have the doctor's secretary pop in to witness a written request, and then to be killed as soon as a second opinion is acquired. Of course, the doctor would have to mention other options, but that's just a basic rule of informed consent. Now, that's the fast and easy track. The slow track isn't much better. For those in the ambiguous category of not reasonably foreseeable death, Bill C-7 says that other options should be discussed and consultations offered, which isn't much, and one would think that such basic steps should already be there for the fast track cases. As for the 90-day waiting period, the palliative care physicians have already pointed out that it's inadequate because it often takes longer to help people manage their symptoms and to find satisfactory treatments and so on. We share that concern, but we also would point out that the 90-day waiting period is itself ambiguous, given that it begins not on the day a written request is signed and dated, as with the 10-day waiting period that would be cut, but on the day the doctor begins to assess a patient's eligibility, which could be months earlier. Now, many people seem to think further expansion of euthanasia is inevitable. This is not true. The Carter decision was very limited in scope, as the court stated at the beginning and end of its decision. This is about Ms. Taylor and persons in her position. She was near death with a known fatal illness, and the court said, we make no pronouncement on other situations where physician-assisted dying may be sought. At the end of its judgment, it bookended its judgment with those things. The lone judge who decided Truchamp failed to appreciate this and failed to recognize Parliament's objectives in limiting MAID to the end-of-life context. Now, it is the responsibility of Parliament and this committee to listen to the concerns of all parties, including disability rights advocates, palliative care physicians, and others, to be clear about its objectives, to defend them against a particular judge, and to enact more responsible policies. Thank you very much.
Thank you very much for that, Mr. Sikkema. And if you can please send us your written submissions as well, or your